All right, very good. All right, good. Welcome everybody again. Let's get started. And let's see, start with the first slide. So thank you guys for coming in. First and foremost, let's go to the agenda. We're going to talk a little bit about sort of the role of a trust in estate planning. What is a trust? We'll get deep into the weeds then about the trust itself and trying to differentiate it from a will. And then we'll go through some use cases so you can kind of see just the power of a trust and why it's something that definitely you should have in your estate plan, at least consider having in your estate plan. All right, so let's jump into it. So what is a trust? Well, first of all, let's take a step back before we dig deep into a trust and just speak about a trust is actually part of a larger estate plan. When you think about the sense of building generational wealth, in other words, building wealth that will continue even past you on to your children, your children's children, there's two phases to that. There's accumulating wealth, and that you may do from working, building, going to get an education and establishing a career. So your earning potential is as high as possible, or maybe a trade, maybe investments, all these various types of things are how you can accumulate wealth. Estate planning is now thinking about how do I transfer that wealth? How do I protect and transfer that wealth to maximize the benefit and even protect my children or whoever I'm going to be passing that wealth on to. So that's where estate planning comes in. And there's a lot of pieces to it, but the focused piece that we're working on right now has to do with trust, which is a central theme of estate planning. So a trust is a part of a good estate plan. So in order for us to talk about a trust, I think, to get to that, the concept of a will, which most people are familiar with, most people say, or I may ask the question, isn't a will good enough? Just have a will. But what a lot of people don't understand, I just had this conversation today, actually, that even if you have a will, which you should have a will, right? You should have a will. So there's nothing wrong with the will. It's just that a trust is even better than a will. So if you have a will, even with the will, you still have to go through probate court. Right? That means if someone passes and they have assets, you have to go to the court. You have to open up a case. In New Jersey, it's a surrogate court in your particular county. And they have to authorize who now has the authority to pass the deed on to your name, open access to bank accounts, access to funds, right? You have to get authority from the state in order to do that. If you don't have a will, then they, through their intestate laws, will determine who will get what or who has authority to do what. If you have a will, you're saying, these are the things I wish to have happen. And the court will most of the time honor them unless there's a challenge or some issue. Why not? So the will is just telling the state your wishes on what you want to have happen, but the state still has the authority to decide who has the authority to do what with your assets. So even if a will, you still have to go through probate, right? It doesn't provide for incapacity. So a will only comes into place when you pass. So when you pass, then the will comes into place. When you get into a trust, you'll see that's a little bit different. It can be problematic against state lines. So if I own a property in New Jersey, I have to go to probate in New Jersey to probate those properties or those assets. If I have a vacation home in Florida, I have to go to Florida in order to probate those items in Florida. It's a state thing. So if you have properties in different states, you have to go through probate in each of those states. Right. So again, a will is still good, and I think you should have one. But you're going to see why a trust is even better. If you have bequeath something to your children, and they're minors, it has to go to, a guardian or someone that's going to be looking after them. I know children can't inherit, but even at 18, let's say if they are adults, then they just get the funds. If it's the house, they get the house. If it's $100,000, get $100,000. And I don't know if an 18-year-old or even a 20-year-old or maybe even 25-year-old is, maybe mature enough to handle that lump sum at one time. You want to make sure that it's preserved over their lifetime as much as possible. And so a will, usually it's a one-time thing. It also, provides direction and protection for a short time. So at your death, this is what happens, right? And that's it. A trust is a little more, is deeper than that. So we'll get into that so you kind of see the differences. A question that we have from Janine, why do I have to go to probate? That's the law. Probate is prove who is next in line in order to inherit the assets. So if you have a will, The will is telling the courts, I thought about this and I want my assets to go to so-and-so, and I pass. And so the court will look at that and say, okay, this is who they, from the court's perspective, is like, I don't know who owns this property. I don't know what should happen to it. So at least if they have a will that's properly executed, then they will say, okay, I will go by what this person says, unless someone can come and challenge, of course. But it's a public proceeding, and the judge will then make a determination. If you don't have that, then now the judges just, they just have to go by their rules, which says, okay, does you have children? Okay, maybe it goes to the children. Do you have a wife? Maybe it goes to the wife. Does it have, so they have to try to, go through their thing. But you have power in the will to say, I want to go to A, to B, to C. But you still have to go to court, because the court has the authority to say, who is next in line to receive these assets. Here's the beautiful thing. That's where trust is different than that. Trust is a better option. And a couple reasons are, number one, first of all, a trust is similar to the will in the sense that it's a legal document, right? It's a legal document. And so, you have an attorney like myself that would draft that up. You'd have it executed properly, witnesses, notary, things like that. Make sure that that's sufficient. And once you have it, then the thing about it is that you can do a lot more things with a trust than you can with a will. So one of the number of things, I'm going to go through this list very quickly, avoids probate. The trust is a family contract, or if it's, within your family, a family contract that you have between yourself, a trustee, and a beneficiary. And so it's private. You don't have to go to court. And so items if anything that's in that trust passes on to the beneficiaries, to the next generation, without any court intervention. And no one has to know it's private. A will is public. You can go to the circuit court, you can look it up and sort of see all these various things, all these various individuals who are having their properties probated. You can go and see that. But a trust is private. You don't have to go to court in order to do that. And we'll go into a little bit to see as you see the details. Managing assets during incapacity. So not just when you die, but also if you're unable to, again, maybe, manage your own affairs. You don't have to wait till you die for that person that you want you to take over. They can take over if you're like disabled, or if you're incapacitated, if you can't, maybe speak or walk or whatever the problem may be. Do you avoid inheritance tax with a trust? No, you don't avoid inheritance tax with a trust in New Jersey. Every state's a little bit different. This has one that's state specific. In some states, you may even have estate taxes. I think Jersey doesn't have estate taxes, but there's inheritance tax, right? And that is, so people who don't know. So in fact, if you are, and if you bequest to someone who is a child, depending on what their level of relationship to you, there may be a tax on it. If it's a child or a spouse, there's no tax. If it ends up being like a cousin or a nephew or niece, there could be a tax on that, a certain percentage. And so there is that. And so I can definitely, if you want more information about that, just send me an email or whatever, and I can take more information about that. But yeah, so trust does not alleviate that particular item. Managing assets during capacity, control over asset distribution, and we can get that in a second. Protects your privacy, as I noted. Provides for minor children. Protects beneficiaries with special needs. We're going to talk about it in a second. Ensuring continuity of asset management. Minimizing estate taxes. Provides for pets, gifting and travel donations, protecting assets from creditors. We're going to talk about it in a second. Asset distribution from multiple beneficiaries, planning for business succession, planning for complex family dynamics, estate planning for non-citizens, and simplifying multi-state estate planning. So if you have a trust and you put property, you have a property in New Jersey and property in Pennsylvania, property in Florida, as long as you put those items to the trust, you don't have to go through probate at all. And they can all seamlessly pass on then to whoever the beneficiaries are, the children or whoever it may be. All right. Okay, so this is how it is on paper, but I'm going to go through a demonstration to kind of show the mechanics of it. And hopefully that will give you a sense of how it works and why it works. And then we're going to go through some use cases. Okay. So these are terms that are used. There are three pretty much individuals that are involved in a trust. We're talking specifically about a revocable living trust and many different types of trusts, but this one we're talking about for right now is the settler. The settler is the person who's creating the trust. The settler could be a person or it could be a couple if it's husband and wife. And they have assets. It could be home, it could be investments, it could be stock, whatever. They have these things. So they're the ones who's going to be creating this contract, all right? And so trust, we kind of look at it as a bucket. right? Because the contract is utilized to create it so that it can hold assets in it. All right. So just follow me for a second. Okay. All right. Now, a part of that too is that you're going to appoint trustee, right? The trustee is the one who's going to manage the bucket and the assets that are in that bucket. All right. So you have a settlor and you have a trustee. So in the beginning, usually, and again, every situation is a bit different, but normally what you would do is you would have the settlor, who could be, yourself or you and your husband, you and your wife, create it. You're the settlor, and then you also appoint yourself as the trustee, right? So you are, Mr. and Mrs. Jeffrey Blair as settlor, but you're also Mr. and Mrs. Jeffrey Blair as trustee of the trust, right? So just hang with me for a second. So at this point, then you're able to manage whatever is in the trust, and during your lifetime. So to you, nothing really changes, right? Nothing really changes, but we're going to get to it in a second. But the point of doing all this is for the benefit of the next role, which is the beneficiary, which could be your children, right? So you're creating this legal document. You're saying that I am creating this trust and I'm appointing this role of a trustee. I'm going to be the first trustee. And they have the management authority to do these various things with these things that are in this trust, right? And I'm doing all of this for the benefit of the beneficiaries, right? Which in my case, I say would be my children, all right? So you got those three roles, all right? Now, once it's created, right, we put up all the parameters around what we need, all the instructions that we need for the trustee to carry out these various things. If I'm incapacitated, these are the things that you can do. If I pass, then these are the things that I want to have happen. You have all these instructions. So many times, depending on it, the trust could be anywhere from like 30 to 100 pages, depending on how detailed we are on the instructions that we want as far as carrying out, the managing the assets, after we're either incapacitated or passed on. Right. So we have that created. That's phase one. Phase one is creating it, naming these individuals, and then the details of what we want to have happen to all the assets that are in this trust. So once we do that, execute it, it's official, done. And again, it's all private. You don't have to record it anywhere. You don't have to give it to a court or anything like that. You just have it amongst you and your family. Okay. Now, the next step then is what's called funding. That's phase two, right? There are two phases to this. One is creating the trust. Second thing is funding the trust. And the way we would do that is, let's say you have a home, we would deed that from however it is now, deed currently, the ownership of this house is now in Mr. and Mrs. Blair. Now it's going to be, the ownership is going to be the trust. Any of the accounts you may have, you have a choice of either, renaming them or into the name of the trust, or you could just make the POD, the payment on death, of the beneficiaries, the trust. Either way, when those items get either retitled or, say you pass and as a beneficiary, those items go into the trust. Now the trust has these items in it, and it has these instructions to what you want to have happen to it. And so now that's all set up. It's created, it's funded, it's set up. Now, if anything happens to me as a settlor, right? Anything as a settlor, if I'm not in the picture, whatever reason, either I'm incapacitated, I can't, whatever, for maybe, some type of sickness, God forbid, or anything like that, or if I pass, because I have my items not in my name, but it's the name of the trust, and because I have a trustee, well, I was a trustee, right? So the next thing you're going to do within that is also have what's called a successor trustee. So when I pass, who's going to take over as trustee to manage my wishes that are laid out in the trust? And the beneficiaries are the beneficiaries, so they stay. So hopefully the illustration kind of shows, well, as long as you have this set up correctly and have it funded correctly, even if I'm out of the picture, my wishes will still be carried out, and I will have appointed a successor trustee after me that's going to carry these out to make sure the beneficiaries, receive it the way I want them to receive it. All right. Hopefully, that illustration helps. Definitely post any questions you may have about this to clarify anything. And of course, if we have our one-on-one conversation, I can go through it in more clarity as well. All right. But again, it's a legal document, and that has all this in there. So I'm gonna go through sometimes having a use case kind of makes it a little bit more understanding of like how you apply this and how it actually works. I have a few that are here right now. Okay. So meet Sarah and James, right? And they're planning for their children's future. So Sarah and James have two young children, Emma, who's 5, and Jake, who's 8. They worry about what happens if they pass away unexpectedly, right? I mean, I think as a parent, That's one of our worst nightmares. Right? Who's going to take care of my kids? I think sometimes you're like, oh, well, I guess my brother will, or my sister will, or a friend will. But, still, it's something we don't like to think about. But, it's something that you can plan for, and also something that a trust can come into play to really assist with this. So here's the problem. If Sarah and James leave their assets outright to their kids, a court-appointed guardian, because kids can't inherit, right? You got to have an adult. So that minor needs to have someone adult who's going to inherit. And in this case, be the guardian who would manage the money until they turn 18. And then at that point, Emma and Jake would receive their full inheritance, regardless of whether they're financially responsible or not. So again, you got a couple of risks there. The court's going to appoint a guardian. Hopefully you trust the guardian with the funds. They're going to use it for the children, not for themselves. Secondly, when the child becomes 18, they get everything, whatever that amount could be. And can they really manage it at 18, and without any guidance, So it's just, there's a better way, and one way is having a trust. In this case, it's called the Children's Trust. So Sarah and James created a Children's Trust, naming Sarah's sister, Lisa, as trustee. So remember that in that situation where you have a trustee and that manages and carries out your instructions. So pay Emma and Jake's. So you can say that money that's in this trust will pay for Emma and Jake's education, not just give it to them outright, but someone will manage it. The trustee will manage it to make sure, pay for their college and transportation, anything that they may need, living expenses. Allow Lisa to decide when and how funds are distributed based on the children's needs. You don't get it outright. And then stagger the distribution, saying so when they finish college, at age 25, they get half, and then when they're 30, they get the rest of it. However you think you want to do it in order to kind of protect your children from themselves, right? Because I know if I was 18 and got a whole bunch of money one time, that wouldn't be a pretty picture. And I think just the maturity is not there. So here's just one example, simple example, in order that you're able to utilize the trust in order again to protect your children kind of from themselves until they have the maturity to handle it, as well as you're having money set aside to make sure it takes care of their college or maybe investments, maybe purchasing their first home and things like that. So you're putting some guidance there in order to how you want the money distributed, and you can do that with a trust. All right. Okay. So that's one example, one use case. Let me show you another one. Meet Brian and Michelle. So they're protecting their son's inheritance from divorce. All right. So Brian is a retired engineer and Susan, a former teacher. They both worked hard their entire lives to build a comfortable life. Again, there's that accumulation phase, right? They own a house, own a home, have a well-funded 401k, life insurance policy, bringing their total assets to over $500,000, right? So the problem, Brian and Michelle have a son, John, who is happily married, for now. They like their daughter-in-law, but they've seen too many divorces turn ugly. They worry that if they leave their estate to John outright and he gets a divorce, half of their hard-earned assets could end up in the hands of his ex-wife. So I told this from Financial Planning Magazine. Some of the clients' biggest concerns for their wealth after they're gone is that someone will take financial advantage of their children or grandchildren. Now, again, they like their daughter-in-law, so they're not saying, but you just worry about that sometimes. Well, there's something that you can do to protect John from that type of situation. If Brian and Michelle set up a Revocable Living Trust and hold the assets for John's benefit, if John ever divorces, his inheritance is protected because it's in the trust. The trust is a separate asset that's not part of John's asset. So even if he's married and gets divorced, it protects them from divorce because it's not a part of John's estate. It's in the trust. The same thing can go to creditors. If for some reason John has creditors that want to come after his assets or anything like that, because it's in a trust, you're not just giving it to him outright, but you're giving to him in a trust, it's protected because it's a separate entity, separate and distinct from John. So it's protected from taxes, creditors, and divorce. That's the power of a trust. Hopefully you're seeing this and it's making sense. Again, if you have any questions, feel free. Here's another one. Meet Lisa, protecting her husband's legacy from a future spouse. Lisa and Mark were married for 30 years, raising 2 children. Mark worked hard to build a solid financial future, leaving behind a home, retirement savings, and a life insurance policy. Like most couples, his will left everything to Lisa, trusting she would later pass it on to their children. Here's the problem. Well, Lori says, "OMG, I never thought about that." Yeah, for sure. No, just there's a great power here in the trust. After Mark, so here's the problem that they have, right? After Mark's passing, Lisa eventually remarried. Now, without a trust in place, all of Mark's assets become a part of Lisa's personal assets, right? Just passes on to the spouse, but what you expect, right? But if Lisa remarries, then it becomes their assets. And if Lisa passes away first before her new husband, he could inherit everything and potentially disinheriting Mark and Lisa's children. So I know that's not the outcome that Mark was planning or thinking about that it can happen, but it does happen and quite often. And many times you will have those sometimes issues between the first set of children and the blended family type of thing, right? So if Mark had used a revocable living trust with a particular structure, a marital trust, was called a Q-tip trust provision, Lisa could have received income for her life, so she would have not just received the assets, but received it as a part of a trust, and received the income for life, ensuring that the principal assets would go to the children upon her passing. So in this approach, allowed Lisa to use the assets during her lifetime, prevented the new spouse from inheriting Mark's assets, and guaranteed that their children received their rightful inheritance, right? Lori has a question: must you have a will if you have revocable trust? Yeah, you would have both, and they would work together. So it would be if you have an estate plan that's centered around a revocable trust, as opposed to a will, you still would have a will. It's what we would call a pour of a will, and it just works together with the trust. So the real meat would be in the trust, but the will is still there, and it's like a catch-all. So anything, again, there's two phases to that trust, right? There's the part where you create the trust, which is the details of what you want to have happen, and then there's the funding. So anything that's not funded into it would have a will that would be like a catch-all. That kind of says pretty much that anything that I didn't put in my trust, I want to put it into the trust just in case I get a chance to do it, and a few other things. So you would have both. You'd have a pour of a will and a trust. It's called a pour of a will. That's the kind of it, but it would have other features that are in it as well, such as guardian for minor children, your any instructions that you want for your final arrangements, just a few other things to it. So a little bit different. And then as long as you're working with an estate planning attorney or myself, then we can kind of make sure that they work together. The last thing you want is to have some instruction in the trust and then have the will say something different. And now you got some conflict between what. You just want to make sure they all work together. Yeah, and so, you would still have a will. Yeah. Pour over. It's called a pour, or two words, pour over will be the type of will that you would utilize when you're having a trust-based estate plan. And again, if we have a one-on-one, I can kind of go through that in more detail with you. All right. So I got a couple more. Just want to show you. I know you guys pretty much are convinced the power of a trust, but I want to show you a couple more scenarios. So meet Rachel and David caring for their special needs child. Rachel and David are a young couple raising their energetic and lovable son, Junior, who has special needs. Their lives are full of joy, structure, and the daily challenges that come with ensuring Junior gets the care and support he needs. Here's the problem. They often worry, what if something happens to us? Who will care for Junior as a minor or as an adult? Will inheritance or life insurance disqualify him from the essential benefits like Medicaid and SSI? With guidance from the estate planning attorney, Rachel and David created what's called a special needs trust, a legal tool that provides for Junior without affecting his benefits eligibility. Appoints a guardian and trustee to oversee Junior's care and financial needs as a minor or an adult, protects his access to government benefits like Medicaid and SSI, and ensures funds are used for the quality of life extras that may not be covered by Medicaid and SSI, education, therapists, recreation, all those various things. So this is a special type of trust, special needs trust. Just finished one today actually for a client, and he's becoming more and more popular. But again, it's a way to solve this problem. If you have special needs children, minors or adults. And if they just get the house, now all of a sudden now they no longer qualify for any of the government benefits. So what you do is you create a special needs trust, and that special needs trust is how they will receive any of their assets, and the trustee would then manage it to make sure they receive the funds they need for all these various things without them, conflicting with any of the benefits they're getting or making them ineligible. It's a special type of trust, but it's very, very, very popular. All right, one last one I have just to show you guys. Okay, meet Harold and Louise, protecting their children's inheritance. So Harold and Louise are a retired couple in the late 70s, living in the modest home they've owned for over 40 years. They have 3 adult children and dream of leaving them a meaningful inheritance, not bills or stress. As their health declines, they worry about affording a nursing home or assisted living. They have been told they don't qualify for Medicaid because they own their home. Worse, even if they do qualify, the Medicaid could seize the home after their deaths, wiping out their children's inheritance, right? Because Medicaid wants to be paid back. They don't want to become a burden on their children's emotionally or financially. So, the trust solution: a Medicaid asset protection trust. With the help of an estate planning attorney, Howard and Louise established a mapped trust, a special type of irrevocable trust that protects assets while planning for Medicaid eligibility. It protects their home and savings from being counted for Medicaid so they become eligible, avoid estate recovery, preserving their home for their children, and maximize their children's inheritance. It also helps plan for long-term care without being a financial burden. Again, another variation of like a special needs trust in a way, similar to that, in the sense that if you put it in this as an asset protection, it's a way you still own it, but it's in the trust. Therefore, now you become eligible for these particular benefits, nursing home, whatever that may be, nursing care, and it won't eat away at the inheritance that you worked so hard in order to pass on to your children and to your beneficiaries. All right. So that was the last one. But just to summarize, and I hope you guys see, you can't do any of this stuff with a will. All of this requires you to have a trust, and because of that, you definitely need to have someone like me, an estate planning attorney, help walk you through it and help create these items for you to make sure that they fit with your specific need. They're very flexible. Each one of those families are different, right? Different situation, different stage in life, but different needs. It wasn't just for someone who's wealthy. It's not just for someone who is even old or retired. So depending on what your circumstances, they definitely can be a valuable tool for you. So the power of a trust, right? Control during and beyond your lifetime, flexible and customizable, the legal power of enforcement. So it's definitely something that will stand up to scrutiny because it's a legal document that's there to protect you and your wishes, and privacy, right? So all these items are things that just between you and your family. You don't have to go to court. It's not published anywhere. It's just instructions that you have how you want to handle your assets. Can you have a pull over and a map? Yeah. You would have both. Yes. Yeah. So again, when I was speaking about a trust now specifically, it definitely doesn't live by itself, right? A trust is a part of an overall comprehensive estate plan. It's probably one of the most important pieces, but you're also going to have other pieces that are attached to it. The will would be a part of that. That poor will be a part of that. You may even have revocable trust and a map trust, depending on the number of assets that you have and the different things you're trying to do. Again, it can be very simple or it can be very complicated depending on your particular situation. But thank you for the question for sure. All right. Next steps. So thank you for hanging in there. Hopefully things I've been talking about make sense. Again, I'm here to help. And if you're interested in this, I'm just give you like a little, a basic understanding of like how the process would go if you wanted to create one, right? Pretty much there are 4 steps. One, the first thing would be having what's called a peace of mind planning session. And that's where, you connect with me. We have the first consultation. Tell me, who you are, what your assets look like, what are you trying to do, what are your challenges that you're thinking about, and I will tell you what your legal options are. And so that if we decide that we're a good fit, and that you want to hire me to be able to create this structure for you, then we go into the design phase. That's number 2. We'll go over it and create these items and go over it with you, double check it, say measure twice, cut once, right? And then we review the documents with you and then we would go into actually signing ceremony. That would become official, right? Again, it'd be, some of these things, again, depending how complex it could be, over 100 pages on all the details that we want to put in there. But it's for your benefit. It's making sure that there's as little ambiguity as possible when it comes to your wishes and how you want things to play out concerning your assets and the protections that you want to afford to them. So that whole process, can, depending how quickly the information goes back and forth, can take anywhere from between, maybe 3 to 6 weeks, depending on that. And then by that time, so just to visualize, if you start this process now, within about a month or so, you would have accomplished addressing any of those risks you may identify with, or any that you may have that we need to even touch on. All right, so it's a powerful thing. It's something that you get started now. So right now on the screen, I'm showing my website URL in order to set the appointment. My phone number is my email. There's a QR code. You can definitely take a picture of that and then go ahead and schedule. And then we can get that process started. In order to prepare for that, once you schedule, then you're going to get a confirmation for that consultation, and there'll be a link there for you to complete an estate planning worksheet. And in that worksheet is where you're going to give some of your basic information, so I can make sure I'm prepared for your particular consultation. Everybody's situation is different, and then also any of your challenges that you may have. Anything. I really am focused on this. I'm worried that I may not be able to be eligible to maybe for a nursing home, or have a special needs child, or any of those things, whatever it may be. That the estate planning worksheet allows you to capture information and help you to prepare for our consultation. Let you guys go and reach out to me, and I can definitely get started in helping you, create a trust or an estate plan that can protect your family and give you peace of mind. All right. Well, thank you, everybody. Enjoy the rest of your evening, and take care.